Very good evening, all the participants. We have done two video lectures on Companies Act in Malaysia, which covered the basic aspects. And this is the third video lecture in the series. In case you want PPTs which are being used in this video, so you can write in the comments box. We have prepared an online quiz also to test your basic understanding of the Companies Act in Malaysia. So you can request a copy of the quiz also. These videos are basically meant for students of company law, which are studying in Malaysia. They could be accountants, they could be law graduates, or professionals trying to have a basic understanding of the Companies Act in Malaysia. In this particular session, we will be covering liquidation of foreign companies, registers management and electronic documentation and compliance, companies regulations, and Islamic securities regulations. So just let me share my screen with you, which covers the liquidation of foreign companies and enforcement. I hope my PPT is visible to you. So, Companies Act 2016, liquidation, foreign companies and enforcement. Section 531. So Section 531, it talks of the creditor rights in liquidation and execution restrictions. So what are the core restrictions? Introduction to creditor execution restrictions. So this section outlines limitations on creditors enforcement actions during company liquidation proceedings. The core rule in case of creditors' right in liquidation is that creditors cannot retain execution or attachment benefits against a liquidator unless execution was completed before winding up commencement. And there is an automatic stay on any ongoing enforcement actions which stand automatically stayed upon an order of liquidation. So what are the key exceptions? Let us have a look at the key exceptions also. One is good faith purchases are an exceptions. So this exception applies for good faith purchases by bailiff from execution proceeds. Court discretion. Court may also grant equitable relief wherever warranted under special circumstances, and in case of voluntary winding up, exceptions apply for voluntary winding up notice periods. So section 531, definition of execution completion. Regarding goods, execution is complete upon seizure and sale of the goods, and partial seizure without sale is not considered as completion. Regarding debt attachment, execution is deemed to be complete upon receipt of the attached debt by the creditor or its agent. Regarding land deals, execution is considered complete upon completion of charging order process over the land. And in case of partial completions, so partial completions are not recognized. Execution must be fully complete before winding up commencement. Section 532 and 533, they talk of the bailiff's duties and court powers. So step 1 is the receive the notice. So bailiff must first receive official notification of the liquidator's appointment to begin the process. Step 2 is delivery to liquidator. So all seized goods and money must be delivered to the liquidator, and execution costs are treated as first charge on the assets. Retain for 14 days for amounts exceeding 100 ringgits. Bailiff must retain funds for 14 days before payment to the liquidator. Court power to declare the dissolution void. So court maintains authority to declare a company dissolution void within 2 years upon application by any interested party. Section 534 talks of offences by company officers in liquidation. If there is a non-disclosure or concealment, any officer who conceals property, debts, or information from the liquidator commits an offense. In case of fraudulent removal of company property in the 12 months before or after winding up commencement, this is also considered to be an offense. Making false statements to the liquidator or in proof of debt constitutes a criminal offense. Officers must not obtain credit or enter transactions while knowing company is being wound up. So these are covered under debt related offenses. So penalties here range for imprisonment up to 5 years or fine up to 3 million ringgits or both for each offense committed. Regarding foreign companies, there are certain registration requirements. So what are the requirements for registration? If a company is incorporated outside Malaysia that carries on business in Malaysia or has a place of business in Malaysia, there is a requirement to get registration. So there is a registration obligation and such company must register itself with the registrar within 1 month of establishing place of business or commencing business in Malaysia. What are the documents required? Copy of the charter or constitution, list of directors, address of the principal place of business in Malaysia. There are certain compliance obligations also which are attached to such companies. One is regarding the registered agent. So such companies must appoint at least one agent which should be resident in Malaysia who is authorized to accept service of the process. Annual filing must lodge annual return and financial statements with the registrar. Penalties in case such companies carry on the business without registration, so they are liable for penalties and officers may also be held personally liable. Regarding accounting records, separate accounting records are required to be maintained for Malaysian operations and auditor approval is required for all such accounting records. Manager must be appointed for Malaysian operations and manager must reside in Malaysia. Subject to Malaysian law and jurisdiction for all Malaysian operations. So such companies which are carrying on business in Malaysia are subject to Malaysian law and jurisdiction for all Malaysian operations. If there is a change in directors, there is a change in constitution or the change in registered agent, so all such changes must be notified to the registrar within 1 month of such change. Regarding branch cessation also, there is a requirement to notify the registrar within 1 month of ceasing to have place of business in Malaysia. Regarding deregistration, they must apply for deregistration when they are ceasing all Malaysian operations. General enforcement powers of the registrar. These are the powers. So the registrar has the power to investigate, to inspect, to issue directions, to deregister, criminal prosecution and civil remedies. Regarding power to investigate, the registrar may investigate affairs of any company where there is reason to believe that the provisions of the Act are being contravened. Registrar may inspect books and records of the company at any time and company is required to cooperate in such cases. Registrar may issue directions to company officers to comply with the provisions of the Act and such directions are considered to be binding on the company and on the officers. Registrar may strike company off register for failure to file returns or carry on the business. Registrar may prosecute companies and officers for breaches of the Act and it may compound offences also. Registrar may apply to court for injunctions and other civil remedies to enforce compliance of various provisions of law. Now let us understand the penalty structure and enforcement options. So general offences where no specific penalty is prescribed. In case of default, fine can be imposed up to 50,000 ringgits in case of first offence and fine up to 1 lakh ringgits in case of subsequent offence. In case of continuing offences, additional daily fine of up to 500 ringgits per day for each day offence continues after conviction. Corporate liability, company and each officer who is in default, both are held liable and officer must have defaulted to be personally liable. Regarding enforcement options, there are criminal penalties in case of false statements or fraudulent conduct, obstruction of registrar. So fine plus imprisonment up to 10 years can be imposed in such cases. Similarly, a registrar may compound offence by collecting sum not exceeding 50% of maximum fine, and it bars prosecution also. So there is a option for compounding of offences also. Limitation period, prosecution must commence within 6 years of the commission of offence. Now regarding enforcement provisions. So there are certain key schedules like Schedule 1. It contains forms prescribed for various applications, notices and returns under the Act. Schedule 2 contains fees payable to the registrar for various filings, registrations and services. Schedule 3 contains provisions applicable to meetings of creditors and contributories in winding up. Schedule 13 talks of transitional provisions relating to companies incorporated under previous Companies Act 1965. Now corporate rescue mechanism, which is the alternative to winding up. So court may appoint judicial manager to manage company's affairs with a view to rescuing the company as a going concern. Company may propose arrangement with creditors and it requires court sanction and it is binding on all creditors if such a scheme of arrangement is approved. Regarding eligibility, company must be unable or likely to become unable to pay the debts. Rescue must be likely to achieve better result than winding up. Automatic moratorium on legal proceedings upon application for judicial management, and it gives breathing space to the company. Scheme requires approval of majority in number representing 75% in value of creditors who are present and voting on this resolution. Let us understand the key takeaways regarding liquidation, foreign companies and enforcement provisions. Execution against company assets is restricted once winding up commences and prior completion is required to retain the benefit. Foreign companies must register with registrar within 1 month of establishing their Malaysian presence. Officers may face up to 5 years imprisonment and 3 million ringgits fine for offences during liquidation. Registrar has broad powers to investigate, inspect, issue directions and prosecute non-compliances. Corporate rescue mechanisms are there, which talks of judicial management or schemes of arrangement. This is available as alternatives to winding up. Compounding of offences is available for up to 50% of maximum fine and it bars subsequent criminal prosecutions. Now let us see some of the register management and electronic documentation and compliances. So section 602, it talks of rectification of registers processes. So first of all, if you want any rectification in any register, then you have to apply. So person aggrieved by an entry applies to the registrar for rectification of the relevant register. Step 2 is the review by registrar. So registrar will review the entries against the criteria. If it is contrary to law, if it is false or misleading, or if it is omitted or misdescribed, or incorrect or erroneous. Step 3 is registrar may request documents or information or require applicant to give notice to interested parties. In the fourth step, registrar approves or refuses the application for rectification, but such decision must be communicated in writing. Aggrieved parties which are not satisfied with the decision of the registrar may appeal to court against registrar's decision to refuse rectification. Now let us understand the registrar's powers and limitations regarding rectification. So registrar is empowered to require the applicant to produce documents furnish information, give notice to other persons interested in the matters. Grounds for rectification include an entry contrary to the law, false or misleading matter, omission or misdescription, incorrect or erroneous entries. If registrar refuses, aggrieved party may appeal to the High Court within the prescribed period. So appeal provision is applicable or available. What are the grounds for refusing? Registrar can refuse if the error does not arise in the ordinary course of performing registrar's duties. Limitation: registrar cannot rectify entries that are outside scope of ordinary administrative functions. And third party rights: registrar must consider rights of third parties who may be affected by any proposed rectification. Electronic filing system. Let us understand the key requirements of electronic filing system. So there is a provision for mandatory e-filing. So all returns, documents and notices must be lodged electronically through the approved e-filing platform by COID, right? System access, security protocols and authorization requirements apply. Users must be registered and authenticated. Document execution, electronic documents must be executed with qualified electronic signature or as prescribed by the registrar. Alternative lodgement, physical lodgement is permitted only where electronic system is unavailable or as approved by the registrar. Affidavits, so sworn statements submitted electronically must meet requirements for notarized documents as prescribed. Registrar certification, so there are procedures for obtaining official certification of regulatory documents via electronic system. Statutory registers. What are the different types of statutory registers that are required to be maintained and what are the requirements as to the maintenance? A register of members, which shall contain full details of all members, shareholdings, dates of entry and cessation, and it has to be kept at the registered office of the company. A register of directors, which shall include details of all directors, including the date of appointment and cessation, consent forms, residential addresses. A register of charges, so all charges created by company, including date of creation, property charged, chargee details, satisfaction dates. A register of debenture holders, name and address of all holders, amount of debentures held, date of entry. A register of beneficial owners, which shall include the ultimate beneficial owners, percentage of ownership, nationality, and it has to be updated within 14 days of change. Similarly, the retention period for all statutory registers is minimum 7 years after the last entry or indefinitely while in use. Registered office. Document custody obligations. The documents at registered office, which may include the constitution, articles of association, a register of members, a register of directors, a register of charges, minutes of meeting. Now regarding public access to such documents, so any person may inspect public registers during business hours and prescribed fees and costs may apply. Electronic maintenance, registers may be maintained electronically if accessible, printable and protected against unauthorized amendment. Regarding access rights and penalties, inspection entitlements are there. So members can inspect for free. Creditors may inspect on justified grounds. Auditors have full access and registrar has inspection authority. Privacy exceptions. So residential addresses of directors may be protected from public inspection in certain circumstances. Penalties. So there is a failure to maintain or make registers available. So fine up to 20,000 ringgits plus 500 ringgits per day in case of continuing default may be imposed. Let us briefly summarize what we have discussed. Filing deadlines. Annual return must be lodged within 30 days of the anniversary of incorporation date each year. Contents required are current details of directors, members, share capital, registered office, charges, and financial statements. Financial statements here include audited financial statements, or in case your company is a small company and they are exempted from certification, so then financial statements must accompany the annual return and they cannot be filed separately. There are late filing penalties. So penalties accrue from day after the deadline and may be compounded. In case of continued failure, they may lead to striking off of the company from the register. Public record. So filed annual returns are public documents and they should be accessible to any person on payment of prescribed fees. Regarding compliance procedures, what are the key areas? Director consent filing. So consent of director to act must be lodged within 14 days of appointment and there is a prescribed form which must be filled for director's consent. In case of company secretary, private company need not have secretary, but public company must appoint licensed secretary within 30 days. In case of change of name, so company may change the name by special resolution and this application regarding change of name has to be lodged with the registrar and then new certificate shall be issued. In case there is a change of constitution, so amendments has to be done by way of special resolution and lodge certified copy with the registrar within 14 days. In case of change of registered office, you notify the registrar in prescribed form within 14 days of change and change shall become effective from the date of notification. In case of change of directors, you have to notify the registrar within 14 days of appointment, resignation or removal of any director. Data protection and register confidentiality. Sensitive personal data. So residential addresses of directors may be withheld from public inspection upon application. Beneficial ownership privacy. While register must be maintained, access to beneficial ownership register is restricted to authorized parties. PDPA compliance. So all personal data in company registers is subject to Personal Data Protection Act of 2010 requirements. Unauthorized access. Accessing registers without authority or for improper purpose is an offense under the Act. Data accuracy. Company officers are responsible for ensuring accuracy of information in statutory registers at all times. Beneficial ownership register. Section 60A to 60F. Who must register? So all companies must maintain a register of beneficial owners which has to be updated within 14 days of any change. Definition of beneficial owner. So person who ultimately owns or controls 20% or more of shares or voting rights either directly or indirectly is considered to be a beneficial owner. What is the information required? So full name, identification number, nationality, residential address, and nature and extent of beneficial interest of such beneficial owner is required to be disclosed. Nominees must disclose beneficial owner details to the company and company must record the same in the register. This register is accessible to law enforcement, regulators, and designated government authorities. If there is a failure to maintain or update such register, fine up to 5 lakh ringgits and in case of continuing offense at 1000 ringgits per day is leviable. So what are the key takeaways from registers, electronic documentation and compliance? A registrar may rectify the registers on application and aggrieved parties may appeal to court against refusal. All returns must be lodged electronically via MyCOID and alternative physical lodgement only with the approval of the registrar. Statutory registers must be maintained at registered office and should be retained for a minimum period of 7 years. Annual returns must be filed within 30 days of incorporation anniversary with financial statements attached. Beneficial ownership register must be maintained and updated within 14 days and it can be accessed only by authorized parties. All changes to directors, registered office, constitution and charges must be notified to the registrar within 14 days. Now, let us go through these companies' regulations. So let us briefly understand the provisions regarding companies regulations 2017. Arrangement of regulations. Let us have an overview. So regulation 1 is regarding citation and commencement, official name and effective date, companies regulations 2017, and effective date is 31st January 2017. Regulation 2 contains interpretation, definitions and interpretation guidelines for all regulatory terminology used throughout the regulations. Regulation 3 is on electronic filing system, which outlines the requirements and procedure for electronic documentation submission via approved platforms. Regulation 4 is regarding the appeal process, which outlines the formal procedure for submitting and processing appeals against the decisions of the registrar. Regulation 5 is on alternative lodgement. So there are approved methods for document submission outside standard electronic channels. Regulation 6 talks of system access, which includes security protocols and authorization requirements for accessing regulatory systems. Regulation 7 is on document execution. So there are rules for proper signing and authentication of regulatory documents which are lodged electronically. Regulation 8 is on fees, which contains the schedule of applicable charges for all regulatory services and filings. Regulation 9 is on additional information, which outlines the requirements for supplementary documentation and supporting material. Regulation 10 is on affidavits, which contains the standard formats for sworn statements and notarized documents in regulatory proceedings. Regulation 11 is on registrar certification, which gives us the procedure for obtaining official certification of regulatory documents. Regulation 12 is on revocation, which outlines the processes for cancellation or withdrawal of previously filed documents. Regulation 1, which is on citation and commencement. Officially. So these regulations are formally cited as the company's regulations 2017 in all official documents. Commencement date is 31st January 2017, which marks the formal implementation of the regulatory framework. These regulations are established under the powers conferred by Section 613 of the Companies Act 2016. These regulations apply to all companies which are registered under the Companies Act 2016 from the commencement date, and in case your company is previously registered under the earlier Companies Act 1965, so then you are also subject to these regulations from the commencement. Regulations gazetted and came into force on 31st January 2017 as per Minister's notification. Regulation 2, which is on interpretation and key definitions, electronic filing system, the approved platform by COID for lodging documents with the registrar electronically, approved format specified by registrar for electronic submission of documents, and it may be updated by registrar notice. Authentication, process of verifying identity of persons lodging the document, including digital signatures and login credentials. Lodgement, act of submitting a document to the registrar through the electronic filing system or alternative method. Qualified electronic signature that meets standards prescribed by Digital Signature Act 1997 and registrar. And working day means a day other than Saturday, Sunday or public holiday in Kuala Lumpur. Regulation 3, which talks of the electronic filing system. So let us see the requirements. Mandatory use. All documents are required to be lodged under Companies Act 2016. They must be lodged via the electronic filing system. Users must register for system access. Company secretaries, directors and authorized agents may register. Documents must be in approved format as specified by the registrar and must include all prescribed fields. System issues acknowledgement upon successful lodgement, which serves as proof of filing for the prescribed period. Where system is unavailable, lodgement deadline is extended by 1 working day for each day of downtime. Regulation 4, which talks of the appeal process. So any person aggrieved by the decision of the registrar on electronic filing or registration may file an appeal. This appeal must be made in writing, which must specify the grounds of appeal, and it has to be submitted within the prescribed period. And prescribed period is within 30 days of the registrar decision or such longer period as the court may permit. So registrar reviews the appeal and may affirm, vary or set aside the original decision. If registrar dismisses the appeal, further appeal to High Court is available within 30 days. So court has discretion to award costs. Registrar's costs not generally awarded in administrative appeals. Regulation 5, which talks of alternative lodgement methods. Physical lodgement is permitted only where electronic system is unavailable, document type is not supported electronically, and registrars approves the same. Documents lodged by post or courier are deemed received on date of actual receipt at registrar's office. Walk-in filing, documents may be submitted in person at prescribed registrar's offices during business hours. For physical lodgement, date of receipt by registrar, not date of posting, is the lodgement date. Physical documents must be in prescribed form, signed in ink, and accompanied by prescribed fees in cash or in an approved payment method. Regulation 6, which talks of system access, security and authorization, user registration. So company secretary, director or authorized agent must register with the registrar to obtain system access credentials. Authentication methods. Username and password, two-factor authentication may be required for high-risk transactions. Authorized users, company may designate multiple authorized users. Each user is responsible for submissions under their credentials. Security obligations, authorized users must safeguard credentials, must not share passwords, must notify registrar of unauthorized access. Registrar has the authority to revoke access for breach of security obligations, cessation of authorized role, or regulatory grounds. Company must maintain board resolution or power of attorney authorizing each external agent to file on its behalf. Regulation 7 regarding document execution. Documents executed electronically using qualified electronic signature as defined by the Digital Signature Act 1997. Where document requires multiple signatories, all must execute electronically before submission. Director signatures on annual returns and financial statements may use approved electronic signature method. Regarding physical execution and witnessing, documents which are lodged physically must be signed in ink, wet ink signature required for prescribed documents. Witnessing, documents requiring witnessing, for example, statutory declarations, must be witnessed in person. Electronic witnessing is not permitted. And documents are rejected if authentication or execution requirements are not met and applicant is notified to remedy the defect. Regulation 8, which talks of fees schedule, annual return. In case of annual return, prescribed fees is based on the company type and share capital, and late filing attracts additional penalty and fees. In case of change notifications, fees apply for filing changes to directors, a registered office, constitution, and share capital. Regarding certification fees, fees for obtaining certified copies of documents, certified extract from register, certificate of incorporation. So these are covered under certification fees. Search fees, fees for public searches of the register, access to filed documents, and company formation. Compounding fees, registrar may compound offences by accepting sum not exceeding 50% of the maximum applicable fine. Regarding waiver or reduction, the registrar may waive or reduce fees in prescribed circumstances, and application is required to be submitted in prescribed form. Regulations 10 to 12. which talks of affidavits, certification, and revocation. Regulation 10. So sworn statements filed with the registrar must be in prescribed form and deponent must appear before commissioner for oaths. Regarding Regulation 10, electronic affidavits, wherever prescribed, affidavits may be sworn electronically using approved digital notarization service. Regulation 11, registrar certification. Registrar may certify documents as true copies and certification serves as evidence of contents in legal proceedings. Regulation 11 regarding certificate of incorporation. So registrar issued certificate is conclusive evidence of incorporation on the date stated in the certificate. Regulation 12 revocation. Documents may be withdrawn before processing, but once processed, revocation requires application and approval. Regulation 12 regarding replacement filings. Erroneous filings may be replaced by filing corrected version and registrar determines which version stands. So now let us see the key takeaways from companies regulations 2017. All documents must be filed electronically via MyCOID when physical alternatives only with registrar approval. Appeals against registrar decision must be lodged within 30 days and further appeal to High Court is available. System downtime extends filing deadlines by 1 working day for each day the system is unavailable. Authorized users are personally responsible for all submissions made using their credentials. Electronic signatures must comply with Digital Signature Act 1997 and physical documents require ink signatures. Registrar certifications are conclusive evidence and affidavits must be sworn before Commissioner for Oaths. Now, let us see the provisions regarding Islamic securities regulations. So, companies prescribed interest for Islamic securities regulations. Regulatory authority and legal foundation. Companies Act 2016 is the parent legislation establishing the overarching regulatory framework for all company-related matters in Malaysia. Paragraph 6131D specifically empowering provision that authorizes the minister to make subsidy regulations on prescribed interests. Regulation 2017, which is derived subsidiary legislation, and these regulations are made under powers conferred by paragraph 6131D, establishing the legal foundation for prescribed interests in Islamic securities. Official citation and status. So companies prescribed interest for Islamic securities, selling and buying negotiated transaction regulations 2017. These were made on 11th of December 2017, which is the official date of regulation creation by the minister. On 12th December 2017 is the commencement date. This is the date when these regulations came into operation and became binding on all participants. Legal status of these regulations is they are in force, currently active and applicable to all Islamic securities transactions in Malaysia. Timelines of regulatory development. So Companies Act, as we know, 2016, it was enacted establishing the overarching regulatory authority for corporate matters. Paragraph 6131D provides specific powers to the minister to create prescribed interest regulations. On 11th of December 2017, regulations were drafted, approved and signed by the minister. On 12th of December, regulations were published in the Gazette and came into immediate effect, and now these are ongoing and are applied to all Islamic securities market participants and transactions. What is the scope and application of these regulations? So these regulations specifically address prescribed interest in shares arising from Islamic securities, selling and buying negotiated transactions. It establishes that such interests qualify as prescribed interests under paragraph 8(9)(d) of the Companies Act 2016. Let us see the applicability and stability. It applies to all approved clearing houses and Securities Commission regulated Islamic securities transactions. No amendments so far have been made since its inception, indicating the regulations have remained effective and fit for purpose. It reflects the stability and continued relevance of the framework in Islamic securities market. Islamic securities transaction. Let us see the key definitions. Islamic securities transaction. This is defined by rules made by an approved clearing house approved by the Securities Commission under Section 9 of the Capital Market and Services Act 2007. Approved clearing house, formally approved by Securities Commission to operate in the Islamic securities market. It establishes transaction rules and ensures settlement. Supplier is the party that initiates the sale of Islamic securities through an approved clearing house, and it is subject to all transaction regulations. User is the party that acquires and retains the transacted Islamic securities for a holding period not exceeding 3 business days. Now, 3 business day holding restriction, users' obligations. Users must not retain transacted Islamic securities for more than 3 business days from date of transaction completion. So this is the holding period limit. The purpose of this limit is to ensure market liquidity. It prevents artificial scarcity and promotes efficient price discovery in Islamic securities trading. The 3-day limit is mandatory for all market participants classified as users, and there are no exceptions to this. In case of failure to comply with these obligations, it may entail a breach of regulatory requirements and may result in disciplinary action by the Securities Commission. So, transaction mechanics and process flow. Stage 1, transaction initiation. Supplier offers Islamic securities through an approved clearing house. Stage 2 is the order matching. User identifies and accepts the offered securities through the clearing house platform. Stage 3 is the settlement arrangement. Clearing house facilitates settlement procedure and records the transaction. Stage 4 is the holding period. So user retains securities for a period not exceeding 3 business days. And stage 5 is position exit. User sells or transfers securities within the 3-day window to maintain market liquidity. Let us understand the Islamic securities market structure. Securities Commission is the primary regulatory authority overseeing the entire Islamic securities market. And Securities Commission approves clearinghouse rules and monitors compliances. Institutions that establish transactions rules and definitions while operating under Securities Commission approval are known as approved clearinghouses, and they ensure enforcement of participant compliance. Suppliers are individuals and institutional participants initiating the sale of Islamic securities, and they must maintain full transparency. Users are participants acquiring Islamic securities, and they must strictly observe 3 business day holding restriction. Compliance framework for market participants. Supplier obligations must comply with all transaction rules of approved clearinghouses, must maintain full transparency in securities offering, and they should adhere to Islamic financial principles. Regarding clearinghouse duties, enforce transaction rules, monitor participant compliance, report violations to Securities Commission, and maintain market integrity standards. So these are the duties of the clearinghouses. Regarding user restrictions, so users must strictly observe the 3 business day holding period, and they should refrain from artificial market manipulation, and they should comply with all clearinghouse settlement procedures. Securities Commission monitors, it oversees the clearinghouse operations, it approves rules and modifications, investigates violations, enforces compliance through appropriate sanctions. Now, what are the benefits of prescribed interest classification? There is a legal certainty. So, prescribed interest status provides clear legal recognition and protection for transaction participants, and it helps in reducing legal uncertainty and risk. Market confidence is gathered. The formal regulatory recognition enhances investor confidence, and it attracts domestic and international capital flows to Islamic securities markets. Market standardization, regulated framework ensures consistency across all Islamic securities transactions, preventing market fragmentation. Islamic finance accessibility, regulatory clarity enables broader participation in Sharia compliant investments and supports growth of Islamic financial markets. Now, what is the prescribed interest status? Paragraph 890. Legal foundation. By virtue of paragraph 890 of the Companies Act 2016, interests arising from Islamic securities, selling and buying negotiated transactions are prescribed interests. Interest arises, so interest in shares is created upon completion of an Islamic securities transaction through an approved clearinghouse. Prescribed classification automatically qualifies as prescribed interest under the Act upon completion of the transaction. Legal recognition, it receives formal acknowledgement in the regulatory framework and is entitled to all rights and protection of prescribed interest. Integration, it forms part of a comprehensive regulatory ecosystem bridging Companies Act 2016 and Capital Market and Services Act 2007. Now let us understand the key takeaways from Islamic securities regulations. These are made under paragraph 6131D of the Companies Act, effective from 12th of December, and no amendments since its inception. It applies to Islamic securities, selling and buying negotiated transactions through approved clearing houses. Suppliers initiate the sales. Users acquire securities but must not hold for more than 3 business days. Interests arising from these transactions are prescribed interests under paragraph 89D of Companies Act 2016. Securities Commission oversees the entire market. Approved clearing houses enforce transaction rules at market level. The framework integrates Companies Act 2016 with Capital Market and Services Act 2007 for comprehensive regulatory coverage. So this was all in the evening session today. These videos are basically designed for law students who are studying company law either at graduation or post-graduation level, or for professionals who are interested in having a basic knowledge of the Companies Act. In case you liked our presentations or videos, you can subscribe to our channels to get regular updates on various Malaysian laws. You can also request a PPT in the comment section by writing your email ID. We have developed some MCQs also for basic understanding, and you can request a copy of the MCQs also on various Malaysian laws, including Companies Act. Thanks for watching this video. Thank you so much.